Hi everyone. I'm Chris Merritt. I'm Vice President of the Rule of Law Institute and its sister organisation, the Rule of Law Education Centre. And my task tonight is very brief. I'll be introducing Henry Ergas, who will be delivering our Robin Speed Memorial Address. A little about Robin. Robin favoured an activist approach to defending the rule of law, which is a doctrine that's widely misunderstood, even by some of our elected lawmakers. Defending the rule of law is not about persuading people to obey the law, even though that's always a good idea. It's about protecting Australians from the misuse of power and from arbitrary rule. It's about defending the right to a fair trial, calling out those who would abandon the presumption of innocence, and championing courts that are not merely independent but impartial. Most importantly, it's also about defending the doctrine of equality, that we should all be equal in the eyes of the law. These are ideas that are beyond party politics and form the bedrock of this country's system of governance. But I'm afraid one of these principles, the idea of equal treatment, is in serious trouble. On the table in front of you is a small booklet containing the findings of the first Rule of Law survey on whether ordinary people still believe they can obtain equal treatment from the legal system. The bad news is that just 47% believe today's legal system is providing equal treatment for everyone, regardless of background. While most people, that's 55%, still rated the legal system as either good or very good, that overall positive assessment is being eroded by concern that identity groups are receiving favoured treatment which is unavailable to the general community. Nationally, concern about favoured treatment for certain groups is held by 64% of all Australians. And if some groups are perceived to be receiving special favourable treatment, that means others are having to make do with something that is less favourable. And that brings me to Henry. Henry's a long-time columnist for The Australian, and in recent times his analysis of the rise of anti-Semitism has been forensic. It's helped explain this phenomenon and has shown how deadly it can be to societies like our own that are based on the idea that everyone is entitled to the equal protection of the law. That idea, equal protection, can be traced all the way back to Magna Carta. And that's what this year's address is all about. From Magna Carta to anti-Semitism, the call for justice for all. Ladies and gentlemen, Henry Ergas.
Thank you, Chris. I am, first of all, very grateful to the Rule of Law Institute for inviting me to deliver the Robin Speed Memorial Address. That is all the more the case as this year marks the 800th anniversary of the 1225 version of Magna Carta, which was granted by Henry III, confirmed by Edward I, and then reconfirmed on at least 36 occasions after that. It was the 1225 version, rather than that signed a decade earlier at Runnymede, which was usually found in English statute books, both manuscript and printed. And when, at the end of the 16th century, the Great Charter, as it was called, was put to work protecting and extending British freedoms, it was on the 1225 version that Sir Edward Coke and the other giants of the common law pinned their case. If the Runnymede Charter of 1215 was, as Sir John Baker, the doyen of English legal history, has argued, a mere footnote to history, that of 1225 played a starring role. Enshrined as the inheritance of all British subjects, central to the liberties that defined the ancient constitution, it came to symbolize the rule of law. It would be easy to show that the symbolism bore a tenuous relation at best to its author's intentions. Already in 1905, Edward Jenks castigated as a myth the portrayal of the Charter as a giant step in the direction of modern liberty. Far from opening the road to freedom, Magna Carta was, he wrote, quote, simply a recognition of the privileges of an aristocratic class. There is in that charge an undeniable element of truth. Yet few things are more potent than myths. And what matters in the case of the Great Charter is the uses to which the myth was put. As Robert Menzies said in Parliament on August 11, 1952, when welcoming the arrival in Australia of one of the 14 then-known copies of the 1297 Charter, a copy his government had acquired for the National Library, it is, quote, not to be supposed that the barons at Runnymede in June of 1215 were thinking of other people. There is no doubt that they were thinking a great deal of their own rights. But however self-interested the barons may have been, the record they secured of their rights had, Menzies went on to say, acquired enormous significance ever since. More than any other single document in English history, it seized the imagination of men of intelligence. And because it seized their imagination, it gave rise to later developments in the expression of civil rights that led up to the Bill of Rights. The fruit of that imagination, Menzies concluded, was the principle of the rule of law. And it is because the Great Charter gave rise to this deep-seated feeling in the English mind, and then to the whole English-speaking mind throughout the world, that it has earned the reverence we accord it to this day. It is consequently no accident that when an original of the Charter was loaned to China, the Chinese authorities banned its public display. Merely citing a document, merely viewing a document, so intimately associated with the rule of law, was considered a threat by a regime built on arbitrariness and fear. Yet there is a paradox worth pondering as we cast our minds back to the time in which the Charter was born. It was, on the one hand, a period that witnessed the creation and consolidation of institutions that made countless lives more peaceful, predictable, and free. But it was also the period that saw the emergence of what R.I. Moore, a distinguished medievalist, famously described as, quote unquote, the persecuting society, relentless in suppressing deviance, savage in its assault on heresy, intensely and increasingly hostile to Jews. Rarely has Walter Benjamin's aphorism that there is no document of civilization which is not at the same time a document of barbarism, seem to have greater bearing. To say that is not to cast a moralizing gaze on a long-gone past. It is a fortunate fact that distant eras cannot be legally tried, for otherwise the vice C.S. Lewis aptly termed chronological snobbery would ensure the courts were swamped with worthless complaints. And that fact is all the more fortunate given the difficulties involved in making sense of a period whose outlook was so radically different from our own. As anyone who has attempted to reconstruct the past knows, historiography is a ship sailing on the dark seas of time and oblivion, and the further away the shores it seeks to illuminate, the dimmer and more flickering is its lamp. Any analysis must therefore come with myriad caveats, but it is worth trying to identify the forces which were at work. At their heart lay the far-reaching centralization of power that characterized what has rightly been called the 12th century revolution in government. Of course, already by the time of the Norman conquest, the governance of what became England was more centralized than that on the continent. But the consolidation of royal authority took an enormous leap forward in the reign of Henry II, which stretched from 1154 to 1159. By that period's end, the foundations were in place for the dominance of the common law and of the king's courts over their competitors, particularly the manorial courts run by the barons. No less importantly, the English courts were in a position to prohibit and effectively suppress private war, prevent the construction of unlicensed castles, control the coinage of money, the regulation of weights and measures, and strictly enforce a monopoly over all litigation concerning freehold property. They had, moreover and crucially, a well-run exchequer that could provide the crown with a reasonably stable stream of revenue. It would take until the ministry of Cardinal Richelieu in the 17th century before the kings of France could command a comparable degree of obedience from that country's 6 great lordships, and subdue, even then only very imperfectly, their inclination to oppose royal authority. Accompanying Henry II's reforms was the systematization of the common law. The first treatise on English law, the Tractatus, attributed to Henry's justiciar, Ranulph de Glanville, was in circulation by 1189, its goal being to bring consistency and greater prestige to judicial decisions. The treatise quotes Justinian's dictum that, quote, "What pleases the prince has the force of law." But it also states, as an established principle, that legitimate laws are those, quote, "settled in council on the advice of the magnates and with the supporting authority of the king." Driving home the point, the treatise's opening words assert that, quote, "Not only must royal power be furnished with arms against rebels and nations which rise up against the king and the realm, but it is also fitting that it should be adorned with majestic laws for the governance of subject and peaceful peoples, so that, crushing the pride of the unbridled and ungovernable with the right hand of strength, and tempering justice for the humble and the meek with the rod of equity, the king may always show himself continually impartial in dealing with his subjects. In that sense, Magna Carta was as much a reflection of as a reaction to the Henrician reforms. It was for sure a reaction in that its aim was to constrain the monarch's increased authority, preserving some, at least, of the baron's privileges. Yet its deeply embedded, highly formalized legalism reflected the vast change that separated the law-infused 13th century from its pre-reform predecessors. That legalism was, however, very far from the ideal of one law for all. Sweeping rights were granted to some, while few rights, if any, were awarded to others. And over the course of the ensuing decades, legalism would coexist with and readily accommodate a drastic hardening in the treatment of marginalized groups. In making sense of that hardening, it is important to note that it was guided by what we would now call intellectuals, highly educated clerics who were mainly doctors in theology and masters of canon law. The emergence of proto-universities in the 11th and 12th centuries and their institutional formalization and recognition in the 13th century created a transnational community of scholars who formed a distinct corporation, separate from society as a whole, specifically focused on learning. There had not really been anything of that kind since the Greek academies. Its result was not just to propel learning, but to accentuate its systematization. Moreover, because the scholars, or schoolmen as they were known, were mobile geographically and between universities on the one hand and the administration of the church and the state on the other, their systematizations of theology and law penetrated every aspect of Europe's governance. Typical of the group, and important to our story, was Master Stephen Langton, a leading scholar of the School of Paris and later Archbishop of Canterbury, who was absolutely instrumental in securing Magna Carta's reissue in 1225. Three of the Charter's most celebrated provisions were due to, and we believe largely drafted by Langton: the freedom of the Church, the guarantee of due process, and the prohibition on the sale of justice. A strict legalist, Langton maintained that just as the book of Deuteronomy had guided the history of the Hebrew people, so written law should guide the activities of kings. But to Langton and his fellow schoolmen, the role of law was not to create a space in which individuals could freely shape their own destiny. It was to contain and confine the damage wreaked by original sin. Nor was there great uncertainty as to what that demanded. While passionately committed to the role of reason, the schoolman's epistemology left no room for doubt, much less for mere opinion. Following Augustine of Hippo, they placed faith at the pinnacle of knowledge. From faith came understanding. Led by that understanding, right reason could both syllogistically deduce the correct answers and place them within a tightly defined intellectual framework. As a result, their work produced a dogma, or orthodoxy, in which arguably for the first time in Western intellectual history, truth was as sharply and comprehensively delineated from falsehood as black was from white. That such an orthodoxy contained immense scope for intolerance hardly needs to be said. Enormously magnifying the risks that posed was the growing dominance of an outlook that combined salvation theodicy with an apocalyptic eschatology. Three fundamental elements were involved. The first, which has deep and obvious biblical roots, was the belief that every event of historical significance was either retribution for sin or reward for virtue. Thus, despite the terrible massacres of Jews the Crusaders had inflicted, the surprising success of the First Crusade, which on 15 July 1099 captured Jerusalem from its Muslim leaders, was regarded as divine endorsement of the quest to restore Christian communities that had been lost to and polluted by unbelievers. However, by exactly the same token, the long run of disasters that began with the terrible defeat of the Crusade of 1101, and even more so, the recapture of Jerusalem by the Saracens in 1187, could only be a severe chastisement for the Church's failure to fully cleanse itself and Christendom of moral failings. Secondly, and even more importantly, the persistence and spread of spiritual pollution did not just incur divine wrath. Rather, according to influential exegetes such as Hubert Honorius, Anselm, and Guerreau, the turmoil affecting and afflicting Christendom heralded an unprecedented crisis of apocalyptic significance in which God's forces would be massed against those of Satan. With history's consummation much closer than many had previously suspected, battle lines were being drawn between, on the one side, faithful Christians, and on the other side, the enemies of God, including heretics, schismatics, infidels, pagans, and Jews. These apocalyptic visions were, it should be stressed, a major deviation from the theology set down by Augustine of Hippo in the 5th century. According to that theology, the future, which lay in the hands of God, was largely unknowable. As Christ had demonstrated his followers about the coming of the end, quote, "Of that day and hour no one knows, not the angels of heaven, but the Father alone." Matthew 24:36. To believe human eyes could pierce the dark glass of God's design was, according to Augustine, a fantasy fit only for carnal-minded fanatics. It was therefore vastly significant that Innocent III, one of the most powerful popes of the Middle Ages, indeed a figure who might well be regarded as the epitome of the papal monarchy, endorsed apocalyptic projections of the arrival of the Antichrist in the encyclical Quia Major, issued in April 1223. "We must put our trust in the Lord," said the encyclical, quote, "who has already given us a sign that the beast is approaching, whose number, according to St. John, will be completed in 666 years, of which already 600 have passed." Third and last, those visions of the impending apocalypse and the resulting urgency of preparing for the final struggle intensified a theological reconsideration of the legitimacy of violence. The change had begun earlier, when the councils of Le Puy in 975 and Charroux in 989 endorsed the use of warfare to protect the Church and advance its mission. By 1053, when Pope Leo IX led his own troops into battle against Norman forces in southern Italy, the preclusions on the clerical deployment of violence had largely faded away. Combined, the crystallization of orthodoxy, the conviction that spiritual pollution threatened the triumph of the Antichrist, and the newly sacralized legitimacy of using force to theological ends, precipitated a far-reaching campaign of moral purification. Its first target was the church itself. From the start of the 11th century, reformers campaigned against the buying and selling of church offices, simony, and clerical marriage and concubinism, Nicolaism. The quote-unquote carnal clerics guilty of these practices, declared Humbert of Silva Candida in his well-known 3 books against the simoniacs, were, quote, worse than pagans and Jews, unquote, while the sacraments they administered were a blasphemous source of spiritual pollution. Banned in stages that began under Leo IX, the elimination of simony and Nicolaism created a strict wall of separation between clerics and the laity, bringing clerics tightly within the hierarchical, disciplined structure of the church. With the ordinary clergy soon being flanked by the emerging mendicant orders, notably the Dominicans, the reforms gave rise to an international organization unprecedented in its geographical reach, its intellectual homogeneity, and its ideological militancy. The purification of the church was, however, merely a prelude to a far more ambitious campaign to reform the flock, indeed, to rid the West entirely of the stain of moral corruption. That campaign could never have had much practical effect if the Church's spiritual claims had little sway over the secular rulers who dominated the organized means of force. But despite all the intense and unending theological controversies about the appropriate hierarchical relationship between the spiritual and temporal powers, the reality was that the governing elites were at least as permeated by piety and at least as terrified of eternal damnation as the lower orders. At a time when oaths were still infused with immense power, virtually every coronation oath in Europe began with a promise to promote, preserve, and protect the Church, so that simply ignoring papal directives would not have been an easy decision for any ruler to take. Magna Carta itself highlighted the prominence of the spiritual in worldly affairs. Its opening words are concessissimus Deo, we concede to God. And its very first chapter pledges that the king and his successors will ensure, quote, that the English Church shall be free and shall have her whole rights and her liberties inviolable. It is equally telling that the primary means of ensuring its enforcement, at least initially, was the threat of excommunication. Indeed, in 1253, the Pope issued a commitment, which was widely circulated in both English and French, to excommunicate any violators of the Charter's promises. As late as the reign of Henry VIII, churchgoers, including the monarch and his entire retinue, were reminded 4 times a year of the anathema automatically visited upon, quote, all those who break any point of the Great Charter. It is therefore unsurprising that the Church's campaign to rid Europe of moral pollution was vigorously backed by the secular powers. And armed with a clearly defined orthodoxy, it was now possible for the Church to unambiguously determine the beliefs that were to be expunged as heretical, leaving the enforcement of its decisions to the increasingly well-organized territorial monarchs. In and of itself, the condemnation of heresy was nothing new. Augustine himself had justified the coercion of heretics, which he portrayed as a great mercy because it rescued them from lying demons. But not even Augustine called for them to be executed. Now, particularly after the issue of Pope Lucius III's decree Ab Abolendum in 1184, and then with the Albigensian crusade against the Cathars launched by Innocent III in 1207, the burning alive of unrepentant heretics became standard practice and was legally established in 1224, just as the new version of Magna Carta was being prepared. At the same time, the process of institutionalizing inquisitions, in which the strict formality of the rules belied the paucity, if not complete absence, of procedural protections for defendants, was underway. Underpinning that marked hardening of persecution was the novel perception of heresy, not solely as a moral defect, but as an infection, a contagion, a lethal poison, comparable to leprosy. In other words, a disease, which, to make matters worse, was chosen and pertinaciously maintained. The heretic was one who was not only ill, but who stubbornly, and hence irrationally, refused the cure, endangering not just himself, but all of Christendom. And it was there that lay the similarity to the emerging and also radically new perception of Jews. While the Church's position on heresy was straightforward, its stance towards Jews was tangled in inconsistencies. Jews were a uniquely tolerated minority, whose identity as the people of the Old Covenant ensured their existence, even as their rejection of the New Covenant rendered them perennial outsiders, despised for their persistence in error. Underpinning that toleration was the vital role they played in Christian eschatology, as the Jews' spontaneous recognition of the truth of Christianity was a necessary step heralding the salvation of the world. The bonum commune, or common good, therefore required that they be preserved, in accordance with the canonist doctrine that, quote, a lesser evil is to be borne so that a greater evil may be prevented. Minus malum toleratur, maius toleratur. But this was a form of toleration based not on rights claimable against the sovereign, but on the sovereign's discretionary power to tolerate or not to tolerate. It was therefore entirely capable of being varied, waived, or even withdrawn. As a result, Jews had to earn toleration every day through good conduct and, in most places, by purchasing the protection of the prince against always lurking aggressors. Even then, however, their freedom was restricted virtually from the start, with the 5th century Theodosian Code limiting the erection of new synagogues, threatening the curtailment of privileges if Jews insulted Christianity, and forbidding Jews from owning Christian slaves. Yet the code also gave Jews some vital protections, for example, outlawing attacks on synagogues. Those protections were extended at the end of the 6th century by Pope Gregory I in his bull, the Constitutio pro Iudeis, which specified that Jews were entitled to, quote-unquote, enjoy their lawful liberties. Restated by Pope Alexander II in his letter Placuit Nobis 1063, those directives largely sheltered Jews from the savagery inflicted on heretics. But here too, the 12th and 13th centuries saw a drastic transformation of attitudes. It is often claimed that the hardening was due to the Church's campaign against usury, as well as a popular reaction against rulers' use of Jewish usury as a form of tax collection. While there is an element of fact in those claims, the change in attitude was far broader and had far graver long-term consequences than a mere tightening of the prohibitions on usury. Thus, Jews had always been seen as marred by spiritual blindness, chechitia, by stubbornness in refusing to accept Christianity, duritia, and by the distortion of faith in their attempt to deny the authority of Jesus, perfidia. Now, however, Jews were, for the very first time, seen not just as morally deficient, but as a positive danger to Christians, whom they allegedly hated and wanted to harm. At its most vicious, that hatred, combined with an allegedly inherent Jewish cruelty, took the form of sadistic rituals inflicted on Christian children, that is, on the most vulnerable Christians imaginable, who were invariably portrayed in stained glass windows as resembling the infant Jesus. Jewish cruelty was epitomized by the blood libel, the claim that Jews slaughtered Christian children so as to use their blood, typically for the making of matzah at Passover. First appearing in France in 1171, that monstrous fantasy's rapid diffusion was accompanied by claims that the cruelty of the Jews was such that they felt no compunction about crucifying Christian children, as they had allegedly done to young William of Norwich in 1144. Nor were children the only victims of Jewish cruelty. Thus, Jewish doctors, who probably accounted for somewhere between a fifth and a quarter of Europe's physicians, were accused of using magic to harm or even kill Christian patients. The Faculty of Medicine at Vienna went so far as to allege that Jewish physicians followed and were required to follow a secret code that demanded that they murder one Christian patient in 10. But the cruelty also took another, more prurient form, the deliberate seduction of Christian maidens who did not realize that they were falling into a trap laid by Jews that would condemn them to eternal damnation. And as if cruelty was not enough, Jews, in their unbridled pride, engaged in appalling displays of arrogance, with Innocent III himself saying that Jews regularly mocked Christian rites by desecrating the host, singing and dancing on Good Friday, and forcing Christian nurses to express their milk into the latrine for 3 days after receiving Christ's body and blood at Easter. To make things worse, Jews had an insatiable hunger for power, a hunger that expressed itself in usury, which was intended to humiliate, ruin, and ultimately suborn Christians allowing Jews to finally dominate the world. Underlying these outrages was the Jews' resentment of the fact, and this assertion too was entirely new, that having been branded with the mark of Cain, Jews were physically, we would now say racially, different from and inferior to Christians. Thus, because they were believed to be especially subject to what medieval medicine termed the melancholic humors, Jewish men not only stank, but anally expelled blood, driving them to seek untainted Christian blood as a vital replacement needed to survive. Since the so-called fluxus sanguinis was an essentially incurable condition, the outrages would continue that the Jews perpetrated for so long as Jews persisted on this earth. Last but by no means least, the Jews, it was said, had abused the protection the Church had in its mercy granted them by effectively abandoning the Old Covenant, which was that protection's fundamental rationale. In particular, claimed the period's leading theologians, they no longer considered themselves bound by the Hebrew Bible and the Mosaic Law. Instead, they now gave their allegiance to the Talmud, a book which, according to Gregory IX, contains, quote, so many offensive things that they are a source of shame to those who repeat them and a horror to those who hear them. To that extent, the Jews were in fact heretics, both against their own faith and that of Christians. Just weeks after Magna Carta was signed at Runnymede in 1215, all those accusations came together at the Fourth Lateran Council. Although it was the 12th ecumenical council in the tradition of the Western Church, Lateran IV was the first great assembly of the whole Church since the Council of Chalcedon in 451. Convened by Innocent III, it was only in the late 19th century that any pontifical conference could come close to rivaling the thoroughness of its preparations, the intellectual and political stature of its participants, and the magnificently choreographed grandeur of its proceedings. High on its agenda was the treatment and future of the Jews. Even listing all the decisions it reached would take far more time than we have available. But as Sir Richard Sutton argued in his classic, The Making of the Middle Ages, the Council's decisions were, quote, the symbolic terminus of a change in attitude which had been developing for a long time. On the one hand, the protection the Church accorded Jews was clearly, unambiguously, and forcibly reaffirmed. On the other, those protections were narrowed to an unprecedented extent. Explicitly denounced as a source of moral and physical pollution, Jews were to be separated by distinctive clothing, prevented from approaching Christians, and whenever possible, converted, if necessary, by threats, though not always the use of force. Moreover, so as to guard against Jewish perfidy, it was decided in a move of crucial significance that the traditional protections were to shield, quote unquote, only those Jews who have presumed not to plot against the Christian faith, unquote. The others were to be regarded as heretics. Handed over to the Inquisition, their fate was to be determined in line with Canon 26, which decreed that the tribunal was to, quote, accept the evidence of Christians against Jews in every case, unquote. The immediate outcome was sweeping measures enacted, often of their own volition, by the secular rulers that reduced Jewish communities to abject poverty. The more indirect, but far more disastrous consequence was a wave of anti-Semitic violence that the authorities repeatedly denounced, but did virtually nothing to punish and suppress. Senior figures in authority, such as Langton in particular, and his very close associate, Robert Grosseteste, a prolific scholar and very eminent scholar, Chancellor of Oxford, and then influential Bishop of Lincoln, regretted the violence. But it is absolutely clear from their private communications with the monarch's officials that they believed the Jews had, through their arrogance, largely brought that violence on themselves. So did the courts, which condemned Jewish victims for alleged provocation far more readily than they ever condemned the perpetrators. Overall, the authorities saw the violence as an unfortunate breach of the peace, but having condemned it, they remorselessly fanned its flames. With France taking the lead in 1289 and England following in July 1290, the campaign to stamp out the moral pollution associated with the Jews culminated in a wave of expulsions, accompanied by expropriations. By November 1st, 1290, All Saints' Day, England was, to use a later ignominious vocabulary, judenfrei, free of Jews. That vocabulary must nonetheless be qualified. As Yosef Yerushalmi, one of the greatest historians of Judaism, has stressed, not even the mendicant friars who mounted the fierce attacks on Jews ever advocating anything resembling the Nazis' final solution. Heart-wrenching as it was, mass expulsion was not mass extermination. Christian respect for the Old Covenant remained sufficiently strong to prevent that. It took the secularization of Europe for the Shoah, the Holocaust, to become conceivable. And once they had settled into their new places of refuge, the Jewish communities that had been robbed of their homes and stripped of their belongings were sufficiently strong, sufficiently adaptable, and sufficiently committed to the faith of their fathers to survive and even grow. Indeed, it was precisely because the Jews survived, and when they were allowed to prosper, that the legacy of that period was so dangerous and so often fatal. The stereotypes it indelibly forged, the cruel Jew who slaughters children, defiles women, arrogantly conspires to gain power over others, and murderously exacts revenge, proved to be bacilli that periodically resurfaced in epidemics of hatred. So too did the pattern of authorities purporting to uphold the rule of law, but not having the will to rigorously enforce it, least of all when it came to attacks on Jews. Seen from a Jewish perspective, Magna Carta, with its promise of justice, was therefore just that, a promissory note. And time after time, when it seemed the promise had come due, those hopes were dashed by a recrudescence of the old monsters, In England, for example, Oliver Cromwell, influenced by Puritan Hebraism, readmitted Jews in 1655. Particularly once the Glorious Revolution inaugurated an era of relative political stability, a new mood appeared to prevail. A mood more tolerant of difference, more adverse to fanaticism, more respectful of rights, more appreciative of what the Renaissance humanists called il vivere civile, living together in a civil manner. There were, in other words, the first signs of what we would regard as the liberal temper, a temper that notes and does not lament the many shades of grey that make up the human existence, that resists the pressure for simple answers, that refuses to succumb to the siren calls of hatred. But when the Jewish Naturalization Act of 1753 was proposed by the Whigs and passed with little debate and less opposition, it took just days before a torrent of pamphlets denounced it, saying any formal recognition of Jewish rights was, quote, as great an affront as we could put upon our established church, or indeed upon any Christian establishment, unquote. Were the legislation to remain in place, one extremely popular orator declared, good English bacon would be banned. Churches would be forcibly converted into synagogues, and children would only be taught to read and write in Hebrew. As a general election loomed, the storms of protest continued to escalate. Panicked by the reaction, and even more so, it must be said, by the risk of losing seats, the governing Whig Party decided to repeal the unpopular legislation, with the bill repealing the quote-unquote Jew Act passing the Commons by 113 votes to 47. As a face-saving measure, Henry Pelham, the Prime Minister, who had sponsored the initial legislation, inserted a preamble in the repealing bill, acknowledging that the effect of the act had been, quote-unquote, to raise discontent and instill disquiet in the minds of many of His Majesty's subjects, end of quote. The government, it went on to say, had been forced by popular clamour to reverse itself. Reflecting on the experience, the Whig Sir George Lyttelton, who had spoken in favour of the original bill, set out the maxim of the new age. A wise government, he said, will know where to yield as well as where to resist. And he continued, quote, public wisdom on some occasions must give way to popular folly, especially in a free country where the humour of the people must be considered every bit as attentively as the humour of a king in an absolute monarchy, end of quote. Perhaps. But there was scant consolation to England's Jews. And as it turned out, they had to wait until 1846, 631 years after Runnymede, before the restrictions on their participation in Britain's political life were lifted, putting in place, at long last, one law for all. Now, across the world, there are good reasons to wonder whether that achievement will, in practice, survive, or whether we Jews will, once again, be, quote-unquote, cancelled from the public place. With the 13th century's monstrous archetypes, not only resurfacing with terrifying speed after October 7, 2023, but gaining a previously unimaginable ascendancy. The liberal temper, which is the crucial underpinning of freedom under law, is everywhere under siege and in most places in retreat. Allow me, therefore, to end with two Jewish stories. The first is from the Bava Metzia, which is the Hebrew for middle gate, which is the second of a series of 3 Talmudic tractates known as the Nezikin. The scene it describes is set in heaven, quite unusually, it must be said, for Talmudic tractates. Heaven, which, it appears, does not consist of halos, lyres, and fluffy clouds. Nor is it tranquil. Rather, it is a place whose virtue is that one is free to argue, to reflect, and most of all, to learn. And what does one so vigorously debate? The law, of course. Here, just as souls long separated from each other by the world's vicissitudes enter paradise linked arm in arm, the great Talmudic sages gather to discuss those finicky points of law that have forever puzzled them. Why? Because there is nothing finer, nothing more meritorious, nothing more worthy of heaven itself than the law which makes it possible for human beings to live together in peace and in justice. The second story is from my lifelong companion, Franz Kafka. As many of you will know, Kafka was not only, or even mainly, a writer. He was the general advocate, chief legal counsel, and eventually general secretary of the Imperial Royal Workmen's Accident Insurance for the Kingdom of Bohemia, which was responsible for the main public insurance and industrial safety scheme in the region widely regarded as, quote-unquote, the Manchester of the Austro-Hungarian Empire. Rising, despite entrenched anti-Semitism, through the Institute's ranks, he worked tirelessly. Indeed, you could say he worked himself to death to ensure the empire's workers' compensation laws were clear, predictable, and properly enforced against even the wealthiest and most powerful industrialists. Hence, his great book, The Judgment. What Kafka does in that book is plunge us back into a world before the single most significant event in Judaism's historical memory, the handing down at Sinai of the law, as a public covenant which binds the community in perpetuity. We blithely assume we are in a world where the law has already been given. Like stripping the paint off a wall, Kafka keeps everything else intact, but peels that assumption away, forcing us to wonder what entitled us to suppose that the law was and would always remain in place. Far from being stable, Kafka suggests, the modern world's ordinariness and orderliness can collapse at any moment, returning us to the world before the law, as one of his most famous and austere stories is aptly called. Not only do we always stand in front of the law, we always risk being thrown into a life prior to the law. And when that happens, our moorings vanish, leaving us disoriented, helpless, alone. Kafka is not George Orwell. It is not totalitarianism that is in his sights. On the contrary, he is the prophet of the injustice that can be wreaked to devastating effect by and in the modern state, with all of its claims to be tolerant and law-abiding. It is an injustice that selects its victims because they are easy targets, and that allows the lives of those it spares to proceed with every semblance of normality while crushing the hopes and dreams of those on whom it has turned. That is the risk Kafka saw looming. The facade of legality remaining intact while its substance was first selectively ignored, then eviscerated. And that, on this 800th anniversary, both of the Great Charter and of the origins of modern anti-Semitism, is the risk we face. With it arises a stark choice. A choice between the law, enforced equally to the benefit of all, and, as the Bava Mitzvah reminds us, worthy of heaven, or the hell of the rule of law for some, insult and intimidation, victimization and violence for others. In once again thanking the Rule of Law Institute for inviting me, and all of you for the kindness of your attention, I can only hope that we have the wisdom and especially the courage to face up to everything that choice demands. Thank you very much.